Challenges to customary sports with bulls in Tamil Nadu, Karnataka and Maharashtra brought a range of interesting questions to a constitution bench of the Supreme Court this week. What fundamental rights does the Indian Constitution guarantee to animals? Are bulls built for these activities? Are the safeguards enacted by all three states sufficient to make the sport cruelty-free for the animals? Animal rights activists and organizations argued against sports like Jallikattu before the Constitution bench led by Justice K.M. Joseph on Tuesday and Wednesday. The states began arguing in support of the practices on Thursday. So what did each side argue on these issues? Let's dive in. A two-judge bench decision of the Supreme Court from 2014 is at the heart of this case. In Animal Welfare Board of India versus A. Nagaraj, the court banned the use of bulls for Jallikattu events in Tamil Nadu and bullock cart races across the country. The court found that the manner in which the sports are played inflict cruelty upon the animals. Animal cruelty, according to the court, is constitutionally prohibited. On January 7, 2017, the union issued a notification directing states to comply with the Nagaraj judgment. However, the notification allowed Jallikattu to be practiced while imposing certain restrictions to accommodate animal rights concerns. Animal rights activists from across the country challenged the notification at the Supreme Court in 2016. However, while the petitions were pending, the Tamil Nadu government passed the Prevention of Cruelty to Animals Tamil Nadu Amendment Act of 2017, which introduced rules under Section 3(2) permitting the sport. The Tamil Nadu Act, along with similar rules from Maharashtra and Karnataka, were also challenged before the Supreme Court. So how is the Nagaraj decision relevant to the current case? PETA and other groups argue that the union's notification allowing bullfighting to continue, albeit with some restrictions, violates the Nagaraj judgment, which found bullfighting to be a cruel and unconstitutional sport. Questioning this logic, Justice Rastogi asked the lawyers challenging the bullfighting to consider that the rules framed by each state change the basis for the Nagaraj judgment. Each set of rules implement restrictions that make the game safer and more humane, hence removing the concern of cruelty that bordered the court in Nagaraj. The response from those challenging the act? The court in Nagaraj found that bulls are mentally and physically unfit for fighting. No matter what restrictions you place, these organizations argue that any sport that forces bulls to fight is an act of cruelty. The petitioners stated that the union can only allow Jallikattu to continue, contrary to the Nagaraj decision, if it can show that it considered some new material that changes the basis for the judgment. The union will show what material it referred to during the hearings next week. Senior advocate Kapil Sibal, arguing for the state of Tamil Nadu, stated that the amendment itself changed the basis for the Nagaraj judgment. He argues that the new rules for Jallikattu are meant to ensure that there is no unnecessary suffering. They make sure that all events are conducted safely while following strict guidelines and require multiple levels of authorization before they can even take place. However, Mr. Sibal cautioned the court against asking questions about the implementation of the rules, as that would enter into the realm of fact-finding, which isn't within the scope of this challenge. The fundamental rights of animals formed another aspect of the hearings this week. The groups challenging bullfighting practices argued that according to the Nagaraj judgment, Article 21 guarantees animals the right to life and dignity. The cruelty inherent to the challenged sports violates this right. These groups also argued that subjecting some bulls to the cruelty of the challenges and not others is an arbitrary act which discriminates against Article 14. Mr. Sibal directly contradicted these claims. He said that the bench in Nagaraj made a mistake by equating the duty of protection owed to animals with animals actually possessing fundamental rights. The obligation on the states is to make sure that animals are not subjected to unnecessary pain and suffering under the Prevention of Cruelty Against Animals Act of 1960. Some pain and suffering is inevitable in the process of domestication, Mr. Sibal argued. Hearings in the challenges to bullfighting will continue next week. The issues likely to be the focus of next week's hearing are if the union and states have the legislative competence to allow a practice banned by the Supreme Court. The factors the union considered while allowing the restricted continuation of bullfight will also be revealed next week. Stay tuned to SEO for more details.